Good morning, ladies and gentlemen. It's a pleasure to welcome you to the third day of our 5-day series on Hot Talk, Passionate Debate for New Age. Before introducing our distinguished guest today, I want to take the opportunity to thank the staff of Boswell Hall and Schuler Auditorium, Justin Van Eaton and his entire staff. There are no people that you can work with that are more cooperative than they, as well as the staff at the Student Union and what they do for us. It's just so deeply appreciated. They make our work so easy. Lanny Stein and his staff at that location. When we chose this particular general topic, we thought that we would have something that would be of interest to many people, and we did not realize at the time we chose these particular subtopics that 4 of the 5 would be front-page news throughout the country the week that we did the forum. And that includes the Patriot Act and free speech and press and censorship, same-sex marriages and privacy, by a development that took place in Atlanta by Choice Point that had to testify last week before the Senate Banking Committee. So we really are current in relation to the topics. Today's topic is sex and politics, the pros and cons of same-sex marriages. Again, you would think that we had ESP because last week a judge in California ruled that same-sex marriages were constitutional under the state constitution of California, and it will be appealed to the state Supreme Court. And last week, the state Supreme Court of Washington heard the same argument. In looking for the speakers to address this topic, we found 2 individuals that have very, very impressive credentials and will be very informative to you. Following their presentations of 20 minutes each, we will invite you to the microphone for questions. I will introduce both, and then I will indicate which one is speaking first. Praveen Fernandez, we welcome you to beautiful Idaho. Mr. Fernandez is a public policy advocate with the Human Rights Campaign in Washington, D.C., where he works on issues relating to HIV, AIDS, gay, lesbian, bisexual, and transgender health issues, sex education, same-sex marriages, and judicial nominations. Our guest has a doctorate of jurisprudence from the University of North Carolina College of Law, which as a native of North Carolina, I can say is a great school, a master's of public health from the University of North Carolina School of Public Health, and a bachelor's degree in biomedical ethics from Brown University. There are many other credentials that are in your program that I would invite you to review. Our second distinguished guest today is Dwight G. Duncan. He is a professor, and I wish to welcome him to beautiful Idaho. Mr. Duncan is a professor at the Southern New England School of Law. He is a leading conservative authority on bioethics, legal ethics, and constitutional law, and has been involved in the ongoing legal debates in relation to gay marriages. Professor Duncan is the principal co-author of the U.S. Supreme Court briefs on the prevailing side of the Supreme Court case called Hurley versus Irish American Gay, Lesbian, and Bisexual Organization in 1995. He holds a bachelor's degree in Greek and Latin from Harvard University, a doctorate of jurisprudence from Georgetown University's Law Center, and he also has a doctorate in canon law from the University of the Holy Cross in Rome, Italy. Would you please welcome both of our guests? It is my pleasure to invite to the podium for the first presentation, Mr. Fernandez.
Thanks so much, Tony. Thanks for everyone who's worked on this conference. I'm honored to be here. A huge thanks to everyone, but a special thanks to Tony, Pam, to Renee, and to Shelley and Megan, who helped set this up today. I do believe that democracy depends on the vibrancy of its citizens and on the sort of vigorous hashing out of issues. So I congratulate you on putting together this event for 35 years where people really hash out hot topics. So congratulations to you. I'm going to divide my remarks into about 4 separate sections. One is the reason why marriage is important, why it's important for all couples, but why for same-sex couples it's worth fighting for. Second, really addressing the component of harm, which is who is harmed if same-sex couples are allowed to marry. Third, I'm going to talk about whatever your feelings are on the subject. I'm going to argue that the federal Constitution is not the place to deal with same-sex marriage. And then lastly, I'm going to address the role of intuition and gut response in forming public policy. I'll start with the first. Why is this worth fighting for? There's a practical reason and there's an emotional reason. I'll start with the practical. Really, there's no real substitute for marriage. Marriage confers roughly 1,100 rights and benefits, and it's an unparalleled way of protecting your relationship and your family. It's a way that couples are able to care for each other, and it's a way that the law respects a relationship and allows you to, that autonomy and that ability to provide for that family. I'll ground that with an example of a parallel. Let's say a couple, Anne and Brenda, who've been together for 10 years, took part in a civil union in Vermont 5 years ago. So they've done as much as they possibly can do under state law to protect their relationship. Let's say they go on a family vacation and they get in an accident in Florida. Well, Anne isn't assured that she can visit Brenda in the hospital because Vermont has civil unions, but unlike marriage, it's not a portable thing. It exists only in state lines. So Anne isn't even assured that she can even visit this person that she's been in a 10-year relationship with in the hospital in case something goes wrong. These things that heterosexual couples take for granted, that if they're married, they'll be able to see their loved one in the time of crisis. That's not there for Anne and Brenda if they're party to a civil union. Second, let's look at Social Security survivor benefits. Let's visit Anne and Brenda again. Say Anne and Brenda both work full-time, but after adopting a child, Anne decides that she's going to be a stay-at-home mom. So Brenda continues to pay into the Social Security system with each paycheck. And let's say Brenda passes away before she hits retirement age. Well, all those Social Security survivor benefits that automatically would go to a heterosexual surviving spouse actually just revert back to the government. Anne and the child that Anne and Brenda have don't have the benefit of that security because those Social Security survivor benefits that Anne has paid into for many years, they don't go to Brenda. They don't go to the child that they had together. There's some basic inequities and ways that we are not able to provide for our families and relationships without marriage. So that's the practical part. The emotional part is the second. People ask me, and people of good faith on both sides ask, why are you fighting for marriage? You know, it's such a loaded term. It has a tradition, a culture, a resonance. It's so meaningful for so many people. Why are you fighting for something so loaded? And I always think that that question presumes its answer right there. That's exactly why we're fighting for it. The truth is, gay and lesbian children grow up in the same families as you do, in the same neighborhoods. They go to the same schools. We watch the same TV shows, we listen to the same corny love songs in junior high school, and we attended the same marriages for years. We're part of that tradition. It's meaningful for you for the same reason it's meaningful for us. It means something. It's part of the fabric of what we know, and it's how we conceive about a lasting commitment between two people. So let me go to the second part, which is the harm. What is the harm if same-sex couples are allowed to marry? I hear about this all the time, and I'm genuinely perplexed about this. Well, I'll address the religious issue. Some people talk about religion, but the truth is no religion will be forced to solemnize a same-sex marriage. We have a split between the civil marriage system and the religious marriage system. There's some religions that already recognize same-sex marriage, such as Reform Judaism or the Unitarian Universalists, and there's some religions that don't recognize the solemnization of same-sex marriage, and that's fine. I grew up Catholic, and so in Maryland, if I married a woman, I could get married in the Catholic Church and have the paperwork transferred so I have a civil marriage. Then I could get a divorce, let's say 2 years later, through the civil system, and could get remarried in Maryland. That doesn't mean the Catholic Church would ever be forced to recognize my divorce or remarry me. We understand that there's two separate systems, and no religion would ever be forced, thanks to the First Amendment, to solemnize any relationship that it didn't believe in solemnizing. So I've yet to see a single well-done study to document how the sky would fall or how locusts would swarm if loving same-sex couples cross town were able to solidify their relationship in a civil ceremony. The truth is, for heterosexual couples, which is the vast majority of the population, life wouldn't change. That's my contention. If we look at just a parallel, marriages have been happening for same-sex couples for almost a year now in Massachusetts. I've yet to see any civil unrest, any riots, locusts, plagues, or any other of the sort of pogrom-like sort of apocryphal visions that people had predicted would happen. Nothing's happened so far. So the only studies I've seen have been rather poorly done and have confused correlation with causation. I'll go to the next part, which is really, regardless of how you feel about same-sex marriage, and regardless of how you feel about the piecemeal progress that's happening state by state, I'll argue that from a public policy perspective, even the most ardent opponent of same-sex marriage should agree that it's bad public policy to deal with this in the federal Constitution. If you look at the Constitution, or even federalism, which is that delicate balance between federal government and state government that we have in this country, this is really not the kind of thing that you deal with in the federal Constitution. Since the Bill of Rights, the amendment process has only been used to expand rights, not to constrict rights. So in other words, our Constitution has this movement of progress to expanding rights. The only exception to that was prohibition. And that was repealed. That was not exactly a successful amendment. That's been the only amendment that restricted rights since the Bill of Rights. Second, states have always had the right to define marriage and family law matters. So, for instance, the age to get married in West Virginia is different from the age to get married in New York. States have always had the right, under our sort of federalist principles of government, to define those intimate sort of relationships and to define marriage on a state level. This would be an intrusion into that state's realm. So there's a reason that states' rights advocates should be rightly wary of determining this issue on a federal constitutional manner through an amendment. So let me go to the third part, which is really about, I guess, fourth. I can't count apparently, but which is about the role of tradition and constitutional issues, moral assessment, and the role of gut impulses in public policy decision. The truth is, when I hear people saying you're trying to change marriage, it's often premised on the notion that marriage hasn't already been changed multiple times. If I were to grant for purposes of argument that this was a change, well, it would be a change to version 5.0 at the very least of marriage. Marriage has been a constant state of flux, and any historian who's looked at marriage just in the last 100 years would look at the changes that we've seen. We've had a Supreme Court case that said that people have the right to marry across race lines. That was just in 1967, where people said it's absolutely unnatural for people of two races to marry. That had to go all the way up to the Supreme Court. Or even if you look at just within a one male, one female marriage, the role of women in marriage has changed profoundly in the last 100 years. At least in the law, women were treated largely as property in the last 100 years. The sad history of sort of southern states with some respects of marriage showed that that just changed in the 70s and 80s. Rape used to be treated as a property crime. And it was a crime against one's father if one were unmarried. It was a crime against one's husband if they were married. In the 70s and 80s, these criminal statutes were revised in southern states to realize that there was such a thing as marital rape and that women were not property as part of a relationship. Before that, it was considered it couldn't be a crime because you couldn't steal one's own property. So what we see is that our conceptions of marriage have gone through a process of changing in the last 100 years that's very, very vigorous. And this is just the latest sort of proposed revision to that. So I'll go into moral assessment, policy, and the role of gut impulse in decision making. I'm not saying that our gut impulses or our moral intuitions shouldn't in some place inform part of our decision-making on public policy. But the truth is, America is a vibrant democracy where sometimes we allow things that might not sit well with our stomach. Because the truth is, in 1968, when the Loving v. Virginia decision was a year old, and Loving v. Virginia is the decision by the Supreme Court that people could marry across race lines, the New York Times did publicized a poll that was done by the Gallup organization in November of 1968. And they said, do you approve or disapprove of marriages between whites and non-whites? Well, 72% of the American public disapproved of those relationships. That's 72% in a Gallup poll that was publicized by the New York Times. And yet, that decision by the Supreme Court was allowed to stand, because the truth was, in America, our tripartite system allows us to sustain things that might not be popular. You don't have to believe in someone's religion to believe that someone has the right to practice one. You don't have to believe in interracial relationships in your personal life before realizing that under our constitutional system, you have a right to engage in those relationships across race lines. So I'll end with two separate quotes. One is from the trial judge in Loving v. Virginia, who said, Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangements, there would be no cause for such unnatural marriages. The fact that he separated the races shows that he did not intend for the races to mix. Well, we know that, of course, the Supreme Court overturned this decision, but it shows that people deeply believe that this was profoundly unnatural and couldn't possibly proceed. And I think that most of us in this room would feel very differently today, which shows that we're in a period of flux and a period of progress where we interrogate our notions, and we do that sort of difficult assessment of where we are and changing that if we decide that progress means otherwise. The other is from the Lawrence decision from 2003, and it talks about the constitutional framers and how wise they were to have a gestural structural document, but not to flesh out the details, to allow the Constitution to be vibrant enough to let it live and grow with changing times. And this quote says, had the framers of the Constitution, talking about the framers of the Constitution, known the components of liberty in its manifold possibilities, they might have been more specific in their drafting. They did not presume to have this insight. They knew that times could blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. Thank you.
Now, ladies and gentlemen, to hear the other side of the issue is Mr. Dwight Duncan.
Thank you, Tony. I appreciate the opportunity to engage in a civil discussion here in the Popcorn Forum on an important issue facing the nation, and Tony Stewart and Renee and Pam and everyone else who's been so terrific are to be commended, I think, in putting together this wonderful event. As most of you know, my own state of Massachusetts last year became the first in the nation to embark on this vast social experiment. And I can't tell you how delighted I am to be in Idaho, because I've never been here before, and my favorite movie the past several years is Napoleon Dynamite. So, gosh, you know. So anyway, for about the past 10 years, there's been an extensive campaign in Europe, North America, and some other countries like South Africa to grant formal legal recognition to same-sex unions, relationships between people of the same sex. Whether this legal recognition takes the form of marriage or a marriage-like status, variously called civil union or domestic partnership, the intent of this campaign, waged largely in the media and in courts and legislatures around the world, is to officially sanction and endorse homosexual relationships and put them on the same level as the spousal relationship between husband and wife. In 2001, Netherlands became the first country in the world to recognize same-sex marriage, and Belgium, Canada, and the state of Massachusetts have since followed suit. This social experiment runs counter to the universal consensus of history across wide divides of geography, religion, and culture as to the nature and meaning of marriage. Historically, marriage has always been understood to be an enduring relationship between a man and a woman and to have some intrinsic relationship to the possibility of having children and thus providing them with both a mother and a father. Even traditions that have recognized polygamous unions have always understood them to involve both sexes and not just one. This understanding of marriage makes sense if we consider why it is that society is vitally interested in the marital relationship, because it is the best setting for the begetting and raising of children who are the future of society. This explains why society and the state require a marriage license for people to get married and regulates the terms and conditions of the dissolution of marriage. Unique among types of friendship, marriage implicates the public interest, principally because the marriage relationship of its nature has the potential for bringing new citizens into the world. After all, one does not generally need a friendship license or need to get the government's approval to break up a friendship. But because marriage is the socially approved setting for sexual intercourse, which is procreative by nature, even if not actually procreative in a particular instance, the government is vitally interested in the welfare of the children who may result and who are best raised by both their mother and their father. Homosexual relationships, which are between persons of the same sex, can never result in children. Any children raised by parents of the same sex are necessarily the son or daughter of some third party and not the offspring of the same-sex union. Furthermore, same-sex parenting, by design, deprives children of either a mother or a father. There is plenty of sociological evidence indicating that children do best when raised by both a mother and a father. Two mothers or two fathers are just not the same. For instance, as I recently noted in an amicus brief filed in Washington State in their same-sex marriage case, which was argued just a couple of weeks ago at their state Supreme Court, quote, families with both a mother and father achieve the best outcomes in raising children along virtually all relevant measures when compared with alternative family forms, under almost every conceivable standard: educational achievement, physical and mental health, drug and alcohol abuse, emotional and behavioral problems, teenage pregnancy, depression, suicide, and criminal activity. Children raised in homes with their biological mother and father, who are married, do better than various other family arrangements that lack the presence of either a mother, a father, or one of the biological parents. Of course, this attempt to radically reconfigure the definition of marriage comes against the background of various attacks on marriage as traditionally understood. The widespread practice of divorce, for example, has weakened our understanding of marital fidelity, as has the practice of extramarital sex. Furthermore, the widespread availability of contraception and abortion have tended to lessen the link between sex, even within marriage, and procreation. And of course, these developments, that is the liberalized divorce regime in which we live, and the widespread availability of contraception and abortion, really have nothing to do with homosexuals. Meanwhile, many people are having children and raising children as single parents. All of these developments, most of which have nothing to do with homosexuality, are undermining our shared, rich, deep understanding of marriage as the permanent union of a man and a woman, intrinsically ordered to the procreation and education of children. Instead, a stripped-down cultural understanding of marriage as simply a type of friendship recognized by the police or friendship with benefits has allowed homosexuals to argue that their relationships too should qualify. No matter how transient or how disconnected to potential offspring, they argue, their relationships are loving and deserve society's good housekeeping seal of approval. This is what I call the marriage is shot to hell anyway argument, and it is actually one of the strongest arguments in favor of recognizing homosexual relationships as some type of marriage. However, the endangered status of marriage in the industrialized West is an argument for being more careful, not less, before changing an institution of such central importance, which is vital for the future of society. To recognize same-sex unions as marriage would definitively sever the link between marriage, procreation, and father-mother parenting. Thus, the burden of proof in making such a radical change should be on the advocates of change, not the advocates of tradition, which is why I think it was appropriate, actually, that Praveen spoke first. As a practical matter, for example, no one really knows what the long-term effect of deliberately raising children without a father or a mother will be, since this experiment is of very recent vintage. Furthermore, the strategy in many countries has involved using open-ended constitutional guarantees of liberty and equality and court cases to force the recognition of same-sex marriage on a reluctant public. So here the issue is, who decides this question about what marriage is and what it entails? That was certainly the case in Canada and in Massachusetts. Here the question is, who should decide this question? In a democratic society, judges who are more or less insulated from public opinion, or legislators who are democratically elected and thus answerable to the people. This past election, in the 11 states in the United States where this question was on the ballot, the traditional understanding of marriage prevailed in all 11 by wide margins, including in fairly liberal states like Oregon. The Massachusetts Supreme Judicial Court, on the other hand, imposed the recognition of same-sex marriage on the Commonwealth by a 4-3 vote of its judges. No wonder that there is now talk of amending state and federal constitutions in the United States to prevent the judicial imposition of same-sex marriage. And you know, one thing that's interesting to note in connection with the discussion of the proposed federal marriage amendment, which Praveen spoke against, is, you know, his claim is that somehow, well, marriage has always been regulated by state law, and it should stay that way. Well, of course, the gay, lesbian advocates and defenders in Massachusetts who brought the Goodrich case, which required the recognition of same-sex marriage under our state constitution, which, by the way, was written in 1780 by John Adams, so it took them really 225 years to discover that John Adams really was mandating same-sex marriage. The same group that brought that suit is now bringing a suit before our state Supreme Judicial Court challenging our 1913 law, which basically says that you can't get married in Massachusetts as a non-resident of Massachusetts if you couldn't get married where you're from, right? So basically, this provision basically prevents people from out of state from flying into Massachusetts to engage in a same-sex marriage and then fly back home and try to force the recognition of this marriage through the federal courts or whatever, where they're from. So basically, my point is this, you know, there are gay advocates who are pushing this. The strategy is get it in one state, use that as a beachhead, and then force the recognition on the rest of the country, right? Once you've got it in one place, force it everywhere else. The result of this, it seems to me, is the only way in which this can possibly be headed off, if the people want, and the people do want, by overwhelming majorities, to preserve our traditional understanding of marriage. The only way to do that is through the federal marriage amendment. And by the way, the process of enacting a constitutional amendment to the United States Constitution is a very difficult, elaborate process. It requires 2/3 of both houses of Congress and 3/4 of the states. The best way to ensure a civil debate on this subject throughout the country is to put the federal marriage amendment before the voters and let them discuss and decide this question, and not have basically one judge, unelected judge in Massachusetts, decide this question for the rest of the country. The claim that same-sex marriage is some kind of civil right also assumes the matter at issue. Many minority groups would dispute the claim that this behavior based on sexual orientation is in any way comparable to innate characteristics like race or sex. Many African Americans, for example, have been appalled by efforts to make gay marriage the new civil rights agenda comparable to racial integration. There are many reasons why same-sex unions are not properly considered to be required by either liberty or equality. They are not required by constitutional liberty because this right has never been recognized at common law. At common law, one had the freedom to marry if one was of legal age, one's intended spouse was of legal age and of the opposite sex, and there were no impediments like an already existing marriage or near degree of kinship. Furthermore, equality between the sexes did not require the legal recognition of same-sex unions because the requirement of male and female affected both sexes equally. Nor was the refusal to recognize same-sex unions a type of invidious discrimination on the basis of sexual orientation because the discrimination was in no way intentional. After all, no one asks what your sexual orientation is when you seek to obtain a marriage license. It's just that marriage is only marriage if it is between the sexes. Indeed, constitutional arguments for the creation of a right to same-sex marriage based on either liberty or equality have this problem about them. They can in no way be limited to the legal recognition of same-sex couples. If what makes a marriage is simply love, pure and simple, there is no reason why 3 or more people cannot be married. And so the door is open to the forced legal recognition of polygamous relationships. Even bans on the marriage of close relatives would become constitutionally suspect if marriage were so understood. Thus, the door would be open, not now maybe, and not by this set of plaintiffs, but eventually and in principle, to incestuous or underage unions. Now, some people have argued that homosexual couples should be given all the legal rights and responsibilities of a marriage, but under another name, like civil union. That is what the state of Vermont tried to do, though it could only extend identical rights and responsibilities under its own state law and not under federal U.S. law. This is because the United States government and at least 40 or so of the 50 states have passed offensive marriage acts which specify that marriage is only between a man and a woman. What's wrong with the marriage in all but name approach to same-sex unions? Let's just call them something else. The problem with this is quite simply that a same-sex partnership is not marriage and so should not be treated like marriage. Male-female couples are different from male-male couples, which are in turn different from female-female couples. Perhaps pairs would be a better term than couples. For same-sex unions, in same-sex unions, there's no sexual difference involved. And if these are different, since same-sex pairs do not exhibit the complementarity of the sexes in the relationship, nor have any ability to procreate, nor provide children with both a mother and a father, then the law should be able to treat them differently. Indeed, to treat these relationships as marriage, or as somehow legally equivalent to marriage, is to commit an injustice against those who are married in the full and proper sense. Their existing marriage is diluted and deprived of its intrinsic connection to procreation and parenting. It is also an injustice to the children raised by same-sex couples, since they are being knowingly deprived of either a mother or a father. Interestingly, Scandinavian countries, which paved the way for the legal recognition of same-sex unions, were reluctant to extend to such couples the ability to adopt or use artificial techniques of reproduction, because they were concerned about the effects of raising children this way. In the United States, however, a number of states, among them Massachusetts and Vermont, allowed same-sex couples to adopt before they allowed them to get married or enter a civil union. Finally, a few words about the underreported underside of this debate, which highlights how much is at stake. Sometimes hidden motivations and intentions can tell you much about what is really going on, even if there is no mention of them in lawyers' briefs and published court opinions. In the summer of 2003, Michael Bronski, a homosexual journalist and self-described queer activist, wondered aloud in a Boston Weekly, quote, "Are we just not the marrying sort? Maybe we should be campaigning for open marriage, or marriage with a tricking on the side option, or that we just want the economic benefits but have no intention of actually being traditionally married marriage. Fighting for marriage is like fighting over yesterday's leftovers rather than coming up with something new and better," unquote. I first became aware of what I call the trashing marriage argument by attending a conference at King's College London in 1999, listening to a parade of international law professors sympathetic to the legal recognition of same-sex unions, some of whom suggested an approach that would effectively destroy marriage. For example, Professor Rebecca Bailey Harris of the University of Bristol, England, provocatively asked, quote, "Is it right to deny lesbians and gay men the right, from a position of equality with heterosexuals, to opt for an institution, however worthless I personally happen to regard it?" Unquote. It is of more than passing interest that the published proceedings omitted her personal testimonial. Obviously, moving into a neighborhood and then trashing it does not resonate with the general public. So the more respectable advocates of same-sex marriage, like Praveen, publicly disavow such claims. Professor Nicholas Bamforth of Oxford University, though, noted at the London conference that according to arguments of radical liberation queer rights advocates, quote, existing concepts of partnership and marriage could be subverted and radically altered by official recognition of socially controversial interpretations of those concepts. For example, by the law recognizing such institutions as being open to persons of the same sex. Interestingly, though, the published version of his presentation omits this discussion, expressly omitting gay liberationist or queer theory arguments. Moreover, Bamforth admits that, quote, a purely deconstructionist analysis is of its very nature unlikely to be of assistance in constructing normative philosophical or constitutional arguments of any sort, unquote. If so, advocating the destruction of marriage is just not helpful to the cause. It does not play well in Peoria. It startles the horses. Indeed, one of the presenters at the London conference was left out of the published version entirely. Professor Kendall Thomas of Columbia Law School, who argued passionately against same-sex marriage on the fascinating grounds that non-normative, non-marital relationships have produced a vibrant queer culture, unquote. He argued that the right to sexual pleasure for all is being undermined by claims for recognition of same-sex marriage, and lamented that achieving same-sex marriage would tend to domesticate the gay and lesbian movement. Nor are such views the idle speculations of academics in London. The New York Times reported from Toronto at the end of August 2003 that, quote, many gays express the fear that gay marriage will undermine their notions of who they are. They say they want to maintain the unique aspects of their culture and their place at the edge of social change. And then it went on and quoted somebody who said, personally, I saw marriage as a dumbing down of gay relationships and wondered aloud, will queers now have to live with the heterosexual forms of guilt associated with something called cheating, unquote? In conclusion, however the law treats same-sex relationships, and it must be recognized that the law in Western democracies is quite permissive and tolerant of such relationships, there is no sense in which they can be considered to be the equivalent to marriage. Common sense says that everyone wants and needs a mother and a father. Changing the definition sends the signal that either a mother or a father are optional, and that acquiring children is the same as begetting them. Thank you.
Megan or Patty, we forgot to bring the water out for them, the bottled water. That was my fault. Can someone bring them some water, please? Thank you very much. It's in the refrigerator. We have our microphone here, and if our staff will raise that microphone, please. And please just come forward and ask your question. This is a good time almost for rebuttal with our distinguished guests. They both will get to answer the question. So if you'll just come to the microphone here, please.
I have a question to ask the second speaker.
Your name, please.
I'm sorry, my name is Pete Townsend, and I have a question on the second speaker. I often hear the phrase being forced upon us. And being old enough to having lived through segregation, I remember hearing that phrase in segregation about integration being forced upon us. And I'm not quite sure what that means. I'm never sure how it's being forced upon me as a heterosexual, how gay marriage is being forced upon me. If you could explain that to me, I don't understand that word, the use forced. And I hear that term used quite a bit. Thanks.
Well, I was referring to the forced recognition of same-sex marriage, which is basically the strategy that the other side is pursuing here has to do with going into court and, invoking constitutional guarantees of liberty or equality in order to force the recognition of same-sex marriage, the legal recognition. And a part of the other side's strategy is, by the way, to keep this off the ballot everywhere, right? Because they don't want the people to decide this issue, basically. And I understand what their position is, They're saying this is a civil right and therefore it should not be subject to popular vote. I'm saying to call it a civil right begs the question, and it assumes what needs to be established, because this has never been recognized anywhere in the world up until 2001 as a marriage.
I think you're right to draw those analogies, actually. It's so funny. I hear this demonization of going to court, people who would go to court, how terrible that is. Well, you would think that we just invented that third branch of government. The truth is, political minorities have been going to court for a long time. The third branch of government was set up to be insulated from the political process. Judges are given lifetime appointments so that they can take unpopular stances. We don't elect our judges every 4 years, and that was by the design of the framers of the Constitution, who said one branch of government should be free of the tyranny of the majority. That was the Federalist Papers that were drawn out. The truth is, Brown versus Board of Education Topeka, which ended desegregation, instituted something that was very popularly unpopular. If you took a poll and looked at desegregation, that court decision forced something upon the people. Loving v. Virginia, which struck down the anti-miscegenation codes, that wasn't legislation, that was a court decision. The truth is that branch of government was supposed to impose sort of constitutional principles and protect political minorities who couldn't protect themselves through legislation.
Next question, please. Yes, question? You're all very polite. Thank you. I told our guests, our audience is always have very good questions and are very polite.
Oh, thank you. I have two brief questions.
Your name, please.
Oh, sorry. Faye Wright. I have two brief questions based on Mr. Duncan's presentation. The first one, if I follow your logic, would it not then be true that single-parent households, which are now a huge percentage of households in this country, by your argument, should be unlawful because there's only a single gender represented? Should I ask the second question simultaneously?
Well, maybe answer that one, then we'll give you.
Okay.
And we'll have both of them answer that.
Well, no, I don't think they should be declared unlawful, because I'm not talking about prohibiting relations. And furthermore, many times single parenting arises for various reasons that I think everybody recognizes. For example, the death of a spouse, are unfortunate and tragic. And so I certainly don't think that the law should somehow prohibit single parenting, okay? But here, when we're talking about marriage, we're talking about basically holding something up as a model and something that, society is saying this is the optimal way for having and raising children. And I'm saying, I think we should hold on to that, right? And I certainly don't think, by the way, I think homosexual couples should be able to live together, and I don't question that, okay? But I think when it comes to marriage, we're talking about essentially the state encouraging and approving something and favoring it. I think it's good for the state to favor mother-father parenting, even if it allows and permits other arrangements.
I mean, I think it's more than just allowing people to stay in sort of single part. There are lots of kids who are raised by single parents, but beyond that, the law also permits infertile couples to get married. The law also permits two 80-year-olds to get married with no presumption that they're going to bring children into this world. The truth is, our system of civil marriage acknowledges that there are other purposes besides procreation to marriage. I mean, 80-year-olds are allowed to get married, and that's not because the law presumes, they're going to bring children into the world. There are multiple purposes that marriage serves, and I think your question addresses one of them.
Thank you very much. What logic is applied in studies that say it takes a man and a woman to raise healthy children, when we all know of the staggering statistics of violence in heterosexual households, especially sexual violence? That's my question.
Yeah, I don't know of those studies. I mean, I certainly didn't cite them. The only studies I've ever seen that have some sort of conclusions is that comparing two-parent households to single-parent households and saying some of the children fare better. Well, there are lots of reasons that could be. There are two incomes there are two people. None of those compared straight couples with gay couples. They compared intact families with single-parent households and said some of these children, well, some of these children went through traumatic divorces. There are lots of reasons that these children in single-parent households had some trauma that they were dealing with. Not one of these studies compared in a clinically controlled setting two-parent opposite-sex couples and two-parent same-sex couples. The studies just aren't there.
Well, I actually would agree with Praveen about this point about the studies. The studies I was citing had to do with comparing heterosexual couples, mainly with alternate parenting arrangements, single parenting being the most prominent. I should say, however, that the studies the other side cites always, right, which is that single-sex parenting is proven. Same-sex parenting is just as good as heterosexual parenting. Those studies all have to do with comparing same-sex couples with single parents, okay? And in which case, you're comparing two fathers with one father or two mothers with one mother, right? And I'm saying, of course, you're going to have more income when you have two. But I think the studies that I know about basically indicate that mother-father parenting is optimal. Now, admittedly, we don't have these long-term studies comparing the two sets of couples in terms of parenting, among other reasons because this is a very novel experiment that we're embarking on. A similar thing, by the way, happened in the early 1970s when our country basically, every state in the Union, with a possible exception of New York, adopted unilateral no-fault divorce because it was thought that would make things better all around, it would eliminate a lot of friction and hostility in divorce. Well, 25 years later, all the studies are in. This was disastrous for women and children, right? By any measure, crime, health, income, virtually any measure. And I'm just saying, I think what happened there should give us pause before we rush down this latest kind of politically correct path, because who knows? I suspect 25 years from now, we'll say, this really wasn't a good thing to deprive children of either a mother or a father. It just wasn't a good thing.
Did you have a question? Oh, you've been studying here a long time? Okay, then. I believe you have a question here. You're also polite.
Hi, my name's Sharon Lind. I'm a sophomore here at NIC, and this question, Mr. Duncan, is mainly aimed at you. According to the argument, marriage is based on the union of a man and a woman, more for procreation and having children and such. I'm curious to know if a couple can't have children, or if they choose not to, does this make it nothing more than a friendship with benefits or a civil union at that point? I'm curious on how you define that according to not only same-sex, but also not having children.
It's a good question. I think, obviously sterile couples can and do get married, heterosexual couples. I don't question the legal status of those marriages. One thing you have to realize is the law operates by generalities, okay? And I think there are reasons why the law doesn't want to get into checking out, a heterosexual couple, whether they actually can have children. And in any case, it seems to me the nature of the relationship is such, it's of the type that does produce children, even if in a particular case it cannot. And that relationship can provide children with both a mother and a father. So I think there are general reasons why we distinguish between these types of couples, basically.
I think it's funny. Dwight says that the law deals with generalizations and says we don't want to interrogate couples and say, well, you do plan to have children, because they're heterosexual couples that don't get married, that get married but don't have children, or they're couples that can have children, and the law doesn't want to interrogate that. It deals with a generalization. But the truth is there are a lot of same-sex couples that get married or form long-term partnerships, if they're not in Massachusetts, and do have children. They adopt children. And the truth is, I think we do a disservice not just to the LGBT community, but to adopted children in general, to make them somehow less because they're not reproductive children. The truth is, adopted children are children just the same. Their parents don't love them any less, whether they're in a heterosexual coupling or a gay coupling. And those children, there are lots of gay couples that have children. And the fact that they're not biologically the product of both of those parents, I don't think makes them any less or in any way demeans that relationship that's there.
Before we have the next question, I see some people leaving for class. At 1 o'clock in the Student Union building, we'll have a panel of people reacting to the speakers, and they will be there too, the speakers will. So if you don't ask a question now, you can at 1 o'clock. I believe the next question is here.
My name is Sina Schmidt, and I have a question for Mr. Duncan. You mentioned that marriage has been weakened through divorce, adultery, and single parents, and that same-sex marriage would therefore be an argument against itself, that it would further dilute the notion of marriage. And I was just wondering whether you wouldn't think that this weakening or rather changing of the status of marriage is maybe a trend in society rather than just a weakening that can be reversed.
That's a good question. I think it is definitely a trend in society, and I think the question is whether, we accelerate that trend or whether we try to say, wait a minute, what is marriage supposed to be about? Why does the government recognize this relationship? Why are there benefits attached to it? And I'm saying, I believe fundamentally, the answer to that question has to do with the children that come out of the relationship, right? That's the reason that basically I don't think friendship plus sex, right, is enough to make marriage, is enough for society to be really interested in encouraging that arrangement, right? But I'm saying it is the case with married male-female couples because of this intrinsic relationship to having children and providing children with both a mother and a father, which is important for the future of society, right? For the optimal raising of children. And I think society would be entitled to privilege that relationship.
Yeah, I mean, I don't really have any response. It's a really good question. I mean, you can look at it as change without ascribing a value to it. And I think the whole, and to paraphrase Dwight, I think he called it the marriage is already shot to hell, sort of argument. I don't think marriage is shot to hell. I think it still has a lot of value. I think it's worth fighting for. And that's why couples still think, that it's something that is something that's worth engaging the courts and fighting for to protect their families. But the interesting thing about people talking about, well, look at infidelity and divorce, et cetera, and I say this about the other side, not Dwight, who I think is a good faith arguer, but a lot of people, I think as part of that movement who are fighting couples are not good faith participants. They talk about how marriage has already suffered through divorce rates, infidelity, et cetera, and that's why we need to keep gay couples from marrying. And I just feel like those arguments go nowhere. I was like, well, so wait, how will keeping gay couples from marrying bring down divorce rates or stop infidelity? I noticed that there's no constitutional amendment proposed to abolish divorce or to abolish infidelity or bring back the criminal statutes that existed in the 1900s for infidelity. I mean, none of these proponents are doing that, but they're concertedly organizing to propose a constitutional amendment on gay marriage. So I'm confused at how they rank these challenges to marriage.
Good morning. My name is Gina Perry. I have a question for Mr. Fernandez, but firstly, I'd like to say, this is a no-brainer here. We can't talk about Judeo-Christian values here in the academic world. We talk about academic freedom, but we don't have any kind of spiritual foundation. And since we don't talk about any kind of spiritual foundation, this is why we are here today. Mr. Fernandez, my question is you obviously look at Europe. Our judicial system here in this country looks at Europe all the time for more and more laws. Is your organization prepared for the decimation of the family here in the United States? Because this is what's going to happen in this country.
I appreciate the question, and I would say I don't think our organization is prepared for the decimation of the family in the United States, but I think it's because we don't think that will happen. And I understand that that's a good faith fear of a lot of people, but I really don't think the decimation of the family will happen. I mean, I've looked at a year of marriages in Massachusetts, and there's no indication that that family has been decimated. I look at some of the advances. I think that some of those same arguments were made when women went to work. And when women sort of, did lots of things, people said that it would lead to the decimation of family. I just think, and I think that those are good faith assertions. I just don't think that'll be borne out.
I guess my perspective is I think the family and marriage in our society is already being decimated, and thus I'm very concerned with sort of the ecology of changes such as Praveen proposes, right? Because I think it would definitively sever any link between marriage and procreation, and I think that link is actually vital to our future. So I am concerned about the future. I'm already concerned about what's happening quite apart from gay marriage. But I think gay marriage basically it validates and confirms these bad trends that I think are prevalent in society for other reasons.
Next question, please. We have a wonderful staff to get that microphone up and down depending on the height.
Thank you. My name is Ryan Robinson. I'm a student here at NIC. My question is for the good Mr. Duncan. You contended that the government is vitally interested in the welfare of our children. As gay couples are already allowed to adopt, would it not be in the best interest of the children to allow their parents to be able to be married, to provide for more legal stability?
Well, I think for the reasons that I gave, I'm actually opposed to gay adoption as a general rule. I still think that it's worthwhile for society to say that mother-father parenting is optimal, and to do this through the marriage law. And I realize that there are issues with couples who are, parenting in alternative arrangements, which are fully legal and permitted by law. I just think that once you establish same-sex marriage, essentially you're going to encourage, the effect will be to encourage this kind of parenting arrangements. And I'm saying, I think that's not a wise move as a matter of public policy. I think society, the government should encourage mother-father parenting and, leave it at that.
I mean, you're right that the reality is that there are a lot of same-sex couples who already have children, and it's not an issue of sort of going forth from a 0 point. This has already happened. There are lots of children who are raised in same-sex households, and they're being denied those protections. And to sacrifice them for some theoretical objective, I think is incredibly calculating. I just think those children are not getting those protections already. They already exist. We're not talking about something that's going to happen 10 years from now. So.
Next question.
My name is Jake, and my question is for Mr. Fernandez. I was just curious on how you feel about the fact that the child is kind of missing out on a point of view as far as parents. For me, I've noticed with kids who have a single parent that they kind of have trouble relating depending upon the sex of the parent and the sex of the child with the opposite sex of the parent. I was just wondering how you feel about that.
I mean, I think parents have to be incredibly wary and careful that they make sure that they provide gender roles for their children and exposure to lots of different parents. But I don't think that those challenges are any different from children who are being raised in single-parent households, children of divorce, et cetera, where they say, well, I do want them to have father figures, or I do want them to have mother figures. I do think it's an effort, and the people that I know who have children have taken that very, very seriously and made sure that, for instance, if it was 2 female couples, made sure that there were uncles around at all times, made sure that there was regular contact with their godparents, and generally picked opposite-sex godparents. This is just the couples that I know that have done that. So if it's 2 women, they picked, 2 men as godparents from two uncles on both sides of their family, who are married to women and heterosexual partners. I think that parents have to be careful about that in any, kind of arrangement that's anything other than a one man, one woman kind of arrangement.
I just thought I'd quote from the experience of one woman who was raised, who's an adult, who was raised by a same-sex couple, and this was quoted in a column by Maggie Gallagher. What was it like for Cassidy, that's the woman's name, being raised by two women she called Mom and my Pat? Quote, when growing up, I always had the feeling of being something unnatural, Cassidy says. I came out of an unnatural relationship. It was something like I shouldn't be there. On a daily basis, it was something I was conflicted with. I used to wish honestly that Pat wasn't there. Why does she oppose same-sex marriage? Quote, it's not something that a seal of approval should be stamped on. We shouldn't say it is a great and wonderful thing, and then you have all these kids who later in life will turn around and realize they've been cheated. The adults chose to have that lifestyle and then have a kid. They are fulfilling their emotional needs. They want to have a child. And they are not taking into account how that's going to feel to the child. There's a clear difference between having same-sex parents and a mom and a dad. And about these studies of alternative family forms, she says, I don't think a fair study could be conducted because children currently in that family wouldn't necessarily be open to speaking their true feelings about it. A few years back, she watched 2020 interviews with children like her. They were asked questions like, are you happy? Do you love your parents? I don't think it's fair to ask them those questions. These are their parents. They aren't going to say they are suffering because they don't want to make their parents feel bad.
And I'm currently a student here at NIC. My question is directed mainly to Mr. Duncan. Throughout this conversation, there's been a lot of talk of case studies and specific logic arguing for or against homosexual marriages. In your last statement, you admittedly said that children can't effectively be asked about such things to make proper studies. So my question is, what logic could there possibly ever be? What study could possibly ever given to say that homosexual marriages are worse than heterosexual marriages dealing with children?
Well, I think it's a kind of thing like no-fault divorce. You have to give it 20 or 25 years, and then proper sociological studies can be done. But clearly, since this is an experiment in its infancy, you can't really. We don't know what nobody really knows. I think what the long-term effects of this will be. Now, the Human Rights Campaign would say, well, really, that's irrelevant because people have a right. People want this, and they have a right to it, right? And I'm saying, I don't think that that's right. And I would like, before we make this kind of a major change in a central institution of our civilization, we should know, we should have some sense that this would be a good thing, as opposed to maybe not such a good thing.
I think I've already addressed the study question, so I don't have anything to add to your very good question, because there are no studies that show that. I profoundly and deeply do not believe that there are going to be these long-term effects that people are talking about. It's a change to marriage, but I don't think it's a deleterious change. But a word of caution about using quotes to make big policy change. And I think Dwight rightly said, this is just one quote of, one teenager raised in a family. But I'll address Maggie Gallagher, who's the columnist who used that quote. It was a teenager who felt alienated from her parents. And I don't mean to be disrespectful when I say newsflash at 11. I know lots of teenagers who at some point felt a little bit alienated from their parents or didn't feel particularly connected. That didn't mean that they were from profoundly broken homes. And I do this not to minimize, her pain. I also have heterosexual friends, a very dear friend of mine who's been married and is still married, and found out that her husband had a long-standing 5-year affair. I heard some of her quotes. I don't think that means that heterosexual men shouldn't have the right to get married. Did she have a lot of genuine pain? We can't make policy based on anecdote and quotes. I know unhappy marriages. I know unhappy parents and unhappy teens. I know scores of them. I just don't think that the conclusions are there for gay marriage based on those quotes.
Next question. Anyone else? Okay.
My name's Andrew. I just have a question about the religious side of marriage. It's something like 90% of America is religious, and marriage seems to have a definition that is more religious-based. And with the federal recognition of marriage, is that an endorsement of a theology? And if so, is it right to go after gay marriage with that term, because that would also be an endorsement of a specific theology as well? So what's the best way to approach that on either side?
No, I mean, I think you're right. I mean, I think our system is somewhat unique compared to like the French system, where the government isn't in the business of talking about marriages. There are sort of parallel systems that are set up, but we use the same term, which is sort of confusing because we use the same term for religious marriages and then civil marriages. But you're right to say that there could even be I think that no religion is going to be forced to perform marriages for same-sex couples. On the other hand, there are some religions that already perform marriages for same-sex couples. So it is an open question about whether enshrining one view in the Constitution would be an impermissible sort of, endorsement clause part of the First Amendment, right? So it is definitely one way or the other. If you make it part of the Constitution, it would be enshrining one view of, one religious view of marriage in the Constitution. So there have been arguments that are made. Our organization haven't really taken that position because we've just sort of said there are two systems. We definitely would support every religion having the right to, deal with same-sex relationship recognition as they would want to.
Well, of course, you're quite right that 90% or whatever of Americans are religious, and there is this religious understanding of marriage largely grounded in the book of Genesis about male and female. He created them, and Jesus Christ in the New Testament sort of quotes that passage, actually, so in some ways endorses it. So I think it is fair to say it's part of the Judeo-Christian tradition. However, in my argument in chief, I didn't make any religious arguments about marriage. And in fact, what I tried to highlight was this interesting fact that this definition of marriage as the union of a man and woman is true for every human society across wide geographical and cultural and religious divides. So, for example, the ancient Roman Empire defined marriage as consortio maris et feminae, the partnership of a man and a woman. And this is pre-Christian Rome, right? Pagan Rome. But it's true in any society, Confucian society, Hindu society, Buddhist society, I mean, whatever, right? We all share this understanding. And I think it has to do with marriage being a kind of basic natural law institution. And the thing about violating the natural law is it has a kind of built-in boomerang, right? You can do it. We can pretend like by a legal fiction that somehow these other relationships are marriage, but I don't think it's going to work. And so that would be my view. And so I don't think it's establishing a religion for society to have this secular understanding of marriage, which is shared by pretty much all of human history.
I'm tall enough. I just want to say that,
you would give us your name, please.
My name is Don Delcom. I'm a student here at NIC. I'm going on my second year, and I'm going into the field of teaching. And one of the reasons I'm going into the field of teaching is to deal with children who, through the acts of the country and their societal experiments, are suffering the consequences. I myself am one of those. And I feel that on this particular issue that I can speak a little bit more than a lot of people because I've had a lot to do with the homosexual community.
Can we get to the question, though, please?
Okay, the question is by doing these things, and this is to both of you, okay? By doing this, I agree, with the social experiment part of it, by allowing children to grow up in a household where the norm isn't there, And societally and statistically, when you look at the destruction of the family worldwide, this is another thing that puts more confusion. It presents more confusion to the children. And so if you don't have the base to make the statistics, basically you are subjecting the children to a social experiment.
Okay,
They're the
thank
ones
you.
that are going to pay it out.
Okay, thank
so
you.
If you would comment on that.
Who wants to go?
I mean, I think I've said that parenting is a difficult job, and I think that parents would have to make every effort to make sure that their child had, exposure to role models all around them, and that's a difficult job. I don't think that's so different from, single-parent families where someone has gotten divorced or someone has lost a spouse, where they have to make that same concerted effort, which would absolutely have to be made to make sure that a child had role models. I mean, I think it's difficult, but in terms of, the size of that challenge, I don't think it's unique to same-sex couples. I think it would be the same in any single-parent household as well. Your point is well taken. There's definitely some effort that's going to be needed to be made.
I don't really have anything to add to what I've already said earlier because your question sort of reflected I think my viewpoint on the subject.
We have only time for only 2 more questions, please.
Hi, my name is Brad Neiman, and my question is for Mr. Fernandez. What I'm wondering is, to begin with, the basis of this debate is we're arguing constitutional rights for and against, obviously. You cited in your argument love, okay? Anybody, I think it's possible, very possible that you're right-headed and right-hearted but wrong-headed in regards to civil rights. And you argued that love should possibly be a right. But a person could say, I love my computer. A polygamist could say, I love all 10 of my wives. A pedophile could say, I love children. But this is why we have laws, because...
Okay, I think your question is, does love come into it? We're about out of time, so Mr.
Can I
Fernandez,
ask my question?
Yeah, would you ask it, please?
Okay, on the basis of arguing for civil rights, it seems to me like you're seeking almost an amendment how rights are derived. They're derived from one can't change their physical characteristics and race, and that's what all civil rights issues are based on. For homosexuality to take place, what is the grounds for your rights? It's a proclivity, and it sounds like you're seeking an amendment to change the way civil rights are derived, other than race and physical characteristics or religious heritage.
Okay, thank you.
It's a good question. In terms of making the race parallel, let me clarify on the outset. We're not fighting for an amendment. We're fighting against an amendment. We're not pushing an amendment for gay marriage. We're fighting an amendment against gay marriage. So the federal marriage amendment that's being discussed is one that would prohibit any state from allowing gay marriage. So that's what the federal amendment is. So we're fighting that. We're not pushing an amendment that would be national. But in terms of your question about genetics and choice, I mean, the body of evidence that's there, and it's not definitive certainly, says that there's a genetic link to homosexuality, that people are born that way and that it is unchanged. So that in the same way that someone is born heterosexual and didn't just wake up and make a choice one day to love women, the choice, the genetic evidence that we have, which is absolutely not definitive yet, but all the evidence we've seen over the past 10 years has said that it isn't a choice, that gay children are born in straight families, and just as their straight siblings did not choose to like someone of the opposite sex, they like someone of the same sex. So good evidence that it's not a choice. But second, your question about whether love is enough, and I've never made the contention that love is enough, and I think you're right that I think this is about protecting families and couples that are existing, loving couples, but I think that there are some very, very differences. These are two consenting adults who enter into a loving monogamous relationship. I think the difference there to pedophilia is I'm not arguing that someone should be able to love a child who's not even at the age of consent. I think there are lots of us who would be offended by that comparison to say, well, this is not about two consenting adults, and there's an issue of abuse there. We don't let children sign contracts for that same reason. This child is in a vulnerable place. In terms of polygamy, there's issues of consent. When two consenting adults decide to marry, right, there are contract issues. It's a bilateral contract. Two people say, I marry you to the exclusion of all others. With a polygamous relationship, there's some contractual questions there. There's some other public policy reasons that we wouldn't allow those. When you want to expand that relationship to 3, do you need permission from both sides, or can one person just decide to expand that? So, for instance, if a husband and wife get married and he decides he wants a second wife, well, do you need consent from wife number 1, or can you just open that contract? When you make a bilateral contract into a 3-party contract, there's some confusion there. When you have children, right now in a marriage, there's a duty of support and an obligation of support both to your spouse and your child. In a polygamous relationship, there's some legitimate legal questions about whether you have the duty to support not just your child, but the child of your spouse and another spouse. So there's some legitimate other reasons there that we don't allow polygamy or pedophilia. And I agree with you. I would never make the contention that just any relationship of liking or love, qualifies you to some sort of legal recognition. What I am saying, however, is that consensual, long-standing same-sex couples deserve the right to protect their coupling and their families. But I've never made the contention that love is enough or liking is enough.
I would just like to pick up on one of the points here, which is, I don't think, love is the essence of marriage. I mean, I think love comes and goes, and to a certain degree, and I think it would be a mistake for the legal institution to be premised simply upon one's feelings at any particular moment. But I will say, one of the problems I see in Praveen's position is I don't understand why it is that among types of love, among types of friendship, we're supposed to privilege romantic sexual friendship over, let's say, 2 elderly sisters who live together and care for each other. Why can't they get the benefits? I mean, nobody thinks they should get married, but there's a certain sense in which if it's about the benefits, it seems to me that couple should be deserving of the benefits. Or grandparents caring for a disabled grandchild, right? Or one grandparent caring for a disabled grandchild. Why can't they get these benefits? So I guess I see equal protection arguments with Praveen's position, which is, well, we should extend marriage to same-sex couples, but draw the line there, right? That's it. Nobody else qualifies, right? I'm saying from a principled point of view, I don't think the law can do that, actually.
This will be our last question, and then you're sure welcome to come at 1 o'clock also.
Hi. My name's Laura. I'm a student at NIC. My question for both of you is, if same-sex marriage were legal, how far ahead would that advance their agenda to adopt children? Do you think that may be on people's agenda just so they can adopt children?
Okay.
I'm talking about...
I think with if same-sex marriage would recognize the ability for same-sex couples to adopt would obviously follow. In other words, it's part and parcel of the project. What I think is unfortunate is in a number of states in this country have embarked on the same-sex adoption route before they ever address the same-sex marriage question, which I think my whole point is the reasons for saying marriage is between a man and woman, it's all about the children. That's why we conceive of marriage that way. So if you concede same-sex adoption, I think it's virtually impossible to say no to same-sex marriage, and I think same-sex marriage necessarily entails same-sex adoption within our legal system.
In the vast majority of states, same-sex couples are already allowed to adopt. Florida has been part of this big legal battle. Florida is one of the few states that has a statutory ban on same-sex adoption, so it's already happened. I mean, so it's not that marriage would lead to that. It's that in the majority of states, same-sex couples are already allowed to adopt. Also, in almost every state, in fact, I think all states, single parents are allowed to adopt, so that's heterosexual. So it's not premised on this two-parent model. Almost every single state will allow a single parent to adopt. So a single woman, regardless of her sexual orientation, a single man will be able to adopt.
I want to say to everyone that asks a question, thank you. It's so great to have a lot of questions in the audience. It's really good to do that here, and the speakers really appreciate that, and other members of the audience. Thank every one of you for your questions, and hope you'll continue to enjoy the week, and we hope to see you at 1 o'clock. Thank you very much.